in all our consultations. And grant that we, having thy fear always before our eyes, and laying aside all private interests, prejudices, and partial affections, the result of all our counsels may be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the King, the public weal, peace and tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen.
Please. Thank you. This meeting of the Honorable Senate of Jamaica for Friday, the 10th day of May, 2024, is called to order. The business cannot proceed without me first indicating that Senators Don Webby, Senator Janice Allen, and Senator Damian Crawford seek the consent of the members to join the meeting online or virtually. Those in favor? Against? Thank you very much. Welcome to our colleagues who are joining us online. And further, I am to identify, bring to your attention, that in the process of this week, both Senator Lambert Brown and Senator Janice Allen celebrated birthdays. Different milestone, different milestone, same event. So we offer to them our kindest regards and trust that they are, their absence is as a result of them spending some time with their families and enjoying themselves and not for any other reason. Oh, okay, yes, of course. Well,
thank you very much, Mr. President.
Okay, good. And we did note that the husband of our esteemed Donna Scott Motley did celebrate her birthday too, and she had a very interesting way of telling people that it was his birthday because she was always busy during this week. Can't do this or that because I have to be looking after Columba's birthday. So congratulations to all of you, and trust that you will have the opportunity to spend many, many more birthdays with us. We're supposed to have had some members of the Horace Clark High School. I said Horace Clark High School is probably St. Mary, you know, but we're not seeing them yet. And there are some persons from the Registrar General's Department who are here for a very specific and important occasion, but I'll say more about that later. Because Mr. Desmond Davis, great, Mr. Desmond Davis, who is the acting chief executive of the RGD, and Ms. Carrie Ann Jones, the acting deputy chief executive, Ms. Nicola White, manager of marketing and planning, and they are here for a specific reason that relates to our own Senator Morris, but in due course I will tell you what that is about. Statements by ministers. Senator Morris Dixon.
Thank you, Mr. President. Mr. President, I rise to deliver a ministerial statement on data protection, and as you said, I have to acknowledge some individuals who are tangentially related to the topic today, especially the team from the RGD that's here and the RGD team, they have a mantra of digitally bold, and they're being very bold, the entire team, the entire staff. And one of the key new deliverables on their side is the introduction of Braille birth certificates, so birth certificates in Braille. And for them, this is very, very important. And for us, the administration generally, this really is a symbol of the fact that the members of the blind community will be able to interact with their birth certificates the same way any citizen would. And members of the community can read their own civil registration document, no longer reliant on others for this task. And I know later today we had expected to do it in the morning with Senator Floyd Morris, giving him his birth certificate. But he had another function, we'll do that later. But he has been a champion of the rights of people living with disabilities, and he's a testament to the fact that a person living with a disability is as remarkable as any other Jamaican. And all persons living with disabilities can achieve remarkable things if we give them the opportunity. And so this initiative of the Braille certificate was championed by Mr. Charlton McFarlane, the former CEO of the RGD. And I remember when he said to me, I have this idea and I've been speaking to the blind community and they've said they want this certificate. And he and the entire staff at the RGD worked tirelessly in order to do it. And the key thing is, it was a conversation with those in the blind community. And as we do more of our policies in relation to digital transformation especially, I know for me, I have to rely on Senator Morris especially in understanding what are those needs, because we cannot stay in our offices and understand those needs. We have to really be interacting quite a bit with those individuals, and we have to get from the community what it is that they want so that we can do it. Accessibility and inclusivity are at the core of the administration's digital transformation strategy. And this includes creating adaptable user interfaces, accessible web and mobile services, and this has been something that Senator Morris has been telling me we need to do, and introducing assistive technologies that can bridge the gap between ability and aspiration. So, Mr. President, we're committed to our future where digital transformation champions accessibility and is inclusive and seeks to the full inclusion of all our citizens. Now to what I am supposed to be speaking on, data protection. Mr. President, 3 short years ago, Jamaica joined the global community in establishing our legislative framework for the creation of a digitally safe country. This framework was made manifest in the form of the Data Protection Act and its regulations. My statement today coincides with, later you'll hear, the tabling of the National Identification and Registration Authority regulations, which will in part see the eventual rollout of a national identification system, a system that has been spoken about for at least 5 decades. The establishment of NERA and the rollout of the digital ID later this year are important to creating a true digital society that can lead to the enhanced efficiency in our country. As we're all aware, the national ID framework must be robust and secure. This means that our data protection framework becomes central to the successful implementation of the national ID, as well as a myriad of other digital initiatives being pursued. Jamaica's Data Protection Act, enacted to safeguard personal data processed by organizations and individuals, presents several key benefits that bolster both privacy rights and economic integrity. Firstly, the Act enhances personal privacy by establishing clear guidelines and responsibilities for data controllers. It mandates that personal data must be collected for specific lawful purposes and with explicit consent. This ensures that individuals have control over their personal information. significantly reducing the risk of misuse and unauthorized access. And this is really important. When I speak to many individuals about data protection, what they say to me is, I get all these text messages on my phone, and I never gave them my number, and they're messaging me all the time, or I'm getting emails from persons that I never gave their information, but it seems as if some other third party gave that information to them. And that's what this act and the regulations that have been put in place will seek to address. Or citizens will have more control over how anyone can use their data. And so, secondly, the Act boosts economic growth and international competitiveness by ensuring that Jamaica's data protection standards align with international norms, such as the GDPR, the General Data Protection Regulation of the European Union. This alignment not only facilitates smoother cross-border data flows, but also attracts foreign businesses and investors who seek assurance that their data handling practices comply with robust data protection laws. And I know Minister Hill, right beside me, a lot of international businesses want to operate in a country that has adequate safeguards for data protection. And so when we're doing this, we are, yes, saying to our citizens, we are protecting your right to privacy and your data privacy rights. But we're also saying to the international community that we have frameworks within our country that are at international standards in terms of the protection of data. And so compliance with such standards is often a prerequisite for international partnerships and ventures, highlighting the economic implications of the Act. Moreover, the Act encourages innovation and technological advancement by providing a clear legal framework for data handling. Companies can leverage the guidelines to develop new technologies and business models without compromising data security. This clear legal framework helps reduce uncertainties and legal risks associated with data-driven innovations, allowing businesses to focus on growth and development while adhering to data protection standards. In summary, our Data Protection Act is pivotal in safeguarding personal privacy, enhancing economic growth, aligning with international standards, and fostering innovation. Its comprehensive approach to data management not only protects individuals, but also supports our aspirations as a competitive player in the global economy. Nonetheless, Mr. President, the new data protection legislation has brought forth concerns from some of our citizens. These include concerns about the implications of such an act on doing business and the maintenance of data privacy and security. The administration and the Office of the Information Commissioner, and our Information Commissioner, Celia Barclay, is here in the gallery. The OIC has been very open to listening to the voices of concerned stakeholders. Anytime you have a new regime, new frameworks in place, it will lead many businesses to have to change their internal processes. And that's what's happening with data protection. And we've had to be listening. And that's a key thing that I have to note. We have been listening, we've been engaging throughout the entire process. We're not just imposing these new rules into an environment that's not conducive. We are communicating and constantly in contact with our stakeholders. Now, we wish to allay those fears today, Mr. President. While our aim is to promote a progressive and sustainable digital environment while ensuring protection for the privacy of personal data, we will ensure this objective is achieved in an equitable and inclusive manner, bringing everyone along this journey. This has been an ongoing process. The law required the full implementation of the Data Protection Act on December 1, 2023. The administration, having consulted with the private sector, acknowledged that most data controllers were not sufficiently prepared to meet the requirements for compliance with the DPA. So we listened. The PSOJ, the Chamber, they wrote their concerns. They worked with their membership to speak with the government and with the OIC to request an extension for compliance. And we listened, and we did so. And we gave a 6-month extension there. So it was a 6-month grace period for all data controllers to become fully compliant with the provisions of the Act. The full implementation of the DPA, the Data Protection Act, would mean or require that necessary regulations being promulgated, a system to be developed and implemented to facilitate registration in keeping with the Act, and the OIC being in a state of readiness to address the concerns of prospective data controllers. And in this vein, 2 sets of regulations have been issued under the Act: the Data Protection Act, Data Protection Regulations 2024, and the Data Protection Act, Data Controller Registration Regulations 2024. Mr. President, I do not seek to speak to all DPA regulations in an extensive manner, as a few are still within the ambit of the other place. What I will say is that these regulations, the 2 that I mentioned, offer clarity on the procedure for registration, inclusive of the particulars to be provided in the registration form. They also provide the considerations for the appointment of the data protection officer and several forms to be utilized in keeping with the provisions of the Act. The registration process will be done electronically, so there is no lots of paper like we have here this morning in front of all of us, via the My OIC portal on the OIC's website, and they are at www.oic.gov.jm. And that's been active since November 30, 2023. And now that the regulations have been published in the Gazette, the registration form on the website is being finalized. The OIC is also at an advanced stage of preparedness for the collection of the applicable fees for registration. And the registration fees are prescribed in the regulations. And for companies, it ranges from 7,500 Jamaican dollars to $25,000. So, or sole traders and individuals with their registration costs would be $7,500, where a company and a public authority would be $25,000. And there's a yearly renewal of registration that ranges from 5,000 Jamaican dollars to 15,000, depending on the size of the business. Since December 1, 2023, data controllers have been able to commence the registration process by creating their unique data controller accounts on the website. As at May 8, 2024, 760 data controllers have created their accounts with the OIC. What that says is that our business community, Mr. Minister Hill, Mr. Business Minister, the business community is complying. And that even without us having everything in place, even with granting a 6-month extension, 760 of our companies have already started the process, which says that this regulation and these regulations and the Act are things that are being embraced by our business community, and they are trying their very best in order to comply with the strictures of the law. It is anticipated, though, that there will be many, many more prospective data controllers who will eventually register with the OIC. And this is based on the number of companies you have registered with the Companies Office of Jamaica. Mr. President, a frequent recommendation from many areas of the society is to take risk or impact-based approaches to the enforcement of the Data Protection Act. The Data Protection Act is very clear that it applies to every business, no matter how small it is. And I have to reiterate that that's what the act that was passed says. Everybody has to be compliant. And so the obligation of a large-scale data processor, though, should never be the same responsibility as that of a smaller processor. And I have said this, you know, my shoemaker should not be held to the same standards of a telecoms provider. And that is what we are currently exploring, and we've especially listened to the MSME sector, and the MSME sector has said, you know, these are difficult rules for us to be able to follow, you know, having a data protection officer and having those systems in place. And so in listening, the administration has adopted their recommendation in terms of a difference between a small-scale processor and a large-scale processor. And our Prime Minister, the Most Honorable Andrew Holness, in his 24-25 budget presentation on March 21, 2024, outlined a priority framework for the registration of data controllers. The OIC will proceed with the registration of data controllers in the following categories as a matter of priority, beginning June 1, 2024. And so the ones that are a priority and who are required to register under the Act are ministries, departments, and agencies of government. There is no exemption to government entities to comply with the Data Protection Act. They have to be compliant on June 1. Data controllers in high-risk sectors such as the financial sector, the health sector, and we know the health sector has a lot of very sensitive data on all of us, tourism and ICT services. And so those entities will have to register come June 1, 2024. Data controllers who are also required to appoint a data protection officer are required to register, as are other controllers who process personal data for in excess of 10,000 data subjects. So you may have a small business with 2 people who are very data heavy in their processing, could be a third-party data processor. So they will have to comply, and those are the priority areas. The data controllers identified for prioritization represent large stakeholder groupings that are important for the protection of consumers who undertake transactions locally, regionally, and internationally. For these consumers, data protection and privacy practices are paramount in the conduct of their day-to-day business. While the OIC's focus during the initial period will be on registering the previously mentioned categories of data controllers, Mr. President, the other data controllers not identified for priority registration will not be precluded from registering if they are ready and wish to do so. And some of them have been ready, are readying themselves, and there's nothing precluding them from registering. And for some of them, in terms of those especially that do business internationally, it will be very good for their business to be registered and be able to show that they are compliant with the Data Protection Act. As part of the journey to full implementation of the DPA, the OIC has been responding to requests from and concerns raised by key stakeholders, and has also been updating its online platforms, including social media accounts, with information for the public. The OIC will shortly be engaging in a media campaign to further increase public awareness of the June 1 end of grace period and also the groups that are prioritized for registration. This will include public service announcement and interviews on radio and other broadcasts and publications. Mr. President, the Office of the Information Commissioner has been engaging with our entire society to ensure full ventilation of the Data Protection Act and its requirements. The OIC has conducted sensitization sessions reaching cumulatively upwards of 7,000 persons. So this is not something where we have put out a law and not done the work to engage. They have engaged 7,000 persons virtually and in person from over 40 organizations within the public and private sectors, and some of these organizations include the Medical Association of Jamaica, the Private Sector Organization of Jamaica, the Insurance Association of Jamaica, ministries. Many ministries have been engaged, including the Ministry of Health, the Ministry of Foreign Affairs and Foreign Trade, eGov, JIS, TPDCO, NHF, JBDC. The real estate sector has been engaged. The Jamaica Deposit Insurance Corporation, the Office of the Prime Minister and the Office of the Cabinet, the Jamaica Civil Service Mutual Thrift Society Limited, and one that I was very happy about was the East Jamaica Conference of Seventh-day Adventists. They felt that they needed to be very much compliant, and they wanted their own sensitization session for their membership so that as they broadcast and live stream their services, that they were doing it in compliance with the Data Protection Act. And so there has been extensive consultation, Mr. President. And furthermore, the OIC has also issued over 100 legal opinions to various stakeholders on the interpretation and application of different provisions of the legislation. So if a company was not clear if it applied to them, or they weren't clear on a particular piece of the act, they could have written to. And we accepted all of that. And the OIC and the Information Commission, as I said, is here. They have issued over 100 legal opinions. So individuals who came to them weren't just told, go look in the act, it is there, or go hire a lawyer. We actually gave legal opinions and assisted in explaining what the requirements were. There is still a far way to go with the implementation of this important legislation, and for data controllers to be fully compliant, and for data subjects, the public, to be properly informed and empowered to exercise their rights under the DPA, and especially that piece where an individual can lodge a complaint to the Information Commissioner for in instances where they feel that their data was not protected as per the Data Protection Act. So we will be engaging the public further and issuing more guidance and assisting wherever we can in getting to the end goal, which is more data privacy in our Jamaican context. So the OIC will, over time, as matters normalize and become embedded, require other data controllers not previously listed to register and ensure their full compliance with the DPA. But that will be done through consultation, as we've done everything so far. In the meantime, the Office of Information Commissioner will continue to focus on increasing awareness, promoting registration, and the implementation of organizational and technical measures for ensuring data protection. And I say to our business community that we don't want to put anyone out of business. It's not in the interest of our country to do that. And this administration is not that type of an administration. We believe the data protection rules are necessary, and we will work with every business to ensure that they are compliant with it. And we will, where we need to, and maybe even with this Senate, have to make adjustments in order to be responsive to our business community. But this is not about being able to fine companies. That's not what it's about. It's about setting up a framework within which we can protect data. And we want to work with every business person to make that a reality. So, Mr. President, in conclusion, the Data Protection Act is as far-reaching as it is transformative. All Jamaicans are encouraged to join the mission to create a digitally safe and secure future, as this data protection framework is a statement of the government's full commitment to securing the privacy of your data. Thank you, Mr. President.
Thank you, Senator Dixon. Senator Fraser-Binns.
Thank you, Mr. President, and thank Minister for that detailed presentation, because there is in fact no doubt that persons are increasingly becoming more and more concerned about their data. I mean, their privacy, and you spoke about persons who will let you know that you're getting all these text messages and you don't know where they get your number from. I too can speak to that, which is a little pesky sometimes. So no, not my private number. So I'm very, very grateful, and having sat on the Data Protection Committee, I continue to give my support for it. Minister, I just want to ask you 3 quick questions. We do not take issue with the extension that was given, because we understand it's a whole new regime. It is something that as a country we had to get used to, and there were resource implications. So we take no issue, but I wondered whether, in light of the fact that the actual commencement date is a few weeks away,
right,
how are we in terms of compliance with that? The other question I have for you is, if you could just spend a little time, and we have a short agenda, but we don't have to prolong it, but if you could help the small companies, less than 10,000, because we talk about the priority list, which are persons that are, companies that are processing data in excess of 10,000 data subjects, 10,000 individuals. If you could help us in the country to understand how data controllers processing less than 10,000 data subjects, whether there's a timeline for compliance, how will they be treated? And I'm happy when you mentioned that the intent is not to penalize, it's to get compliance and to work with them. So if you could help the country to understand how these particularly small enterprises will be treated and what assistance, if any, will be given to them. I'm very pleased. I did not know that the OIC actually offers legal opinion, and I'm particularly pleased because Senator Scott Motter will tell you that it has become, the whole data protection has carved out a whole new venture for entrepreneurs, particularly within the legal fraternity, and we support that. I mean, but we also understand that there may be cost implications for small companies. So I was very happy to find out that the OIC offers legal opinion. If you could also help the public in terms of providing contact information, is there a helpline? If you need more information, to whom do you call, to whom do you speak, where do you call, if there's a helpline, and what is it you can do to get some further assistance in that regard. And the final thing that I want to ask you to just explain a little bit more for the public is on page 3, when we're speaking about the smaller companies and what is required, and you mentioned here electronic storage secured using at least 3 privacy and security measures. Again, for the small enterprise, are we talking about storing online? Are we talking about a backup server? You know, if one really were to expand their minds as to what this includes, there is also a cost implication. And if you could just help, again, us to understand that. So those are my 3 questions, ministers. Thank you. Before I sit, Mr. President, I just wish you to know that Senator Allen indicates that she has a question, with your permission.
Certainly. Let me take Senator Allen's questions first, and then you can respond to both if there is nothing else. Senator Allen?
Thank you very much, Mr. President, and thank you very much, Minister, for the statement. As for me, just like my colleague, Senator Fraser Binns, a lot of things have become a little bit more clear. I wanted to tag on to the second question that Senator Fraser Binns raised, particularly using the example of legal services, because you made mention that the exempted group, at least for up to June 1, for this time frame, includes those who process less than 10,000 data subjects. But at the same time, you made mention of those who manage or receive personal information for people. So, for example, clients provide information to law firms, and it could be a one-person operation, a sole practitioner, who doesn't process more than 10,000 data points, but at the same time processes personal information. I wonder if we could get some clarity on where that group would fall, and whether they are also being given that extra time beyond June 1, and also when is that date for them to become compliant.
Thank you very much, Senator Allen.
Mr. President, through you, I'll respond to those questions, and hopefully I got all of them. Where are we with June 1, 2023 in terms of compliance? We are ready. The OIC, who is right there, Celia, has been doing a lot of work in terms of getting the website up, getting the forms up, having the payment portal. You'd understand that a payment portal is absolutely important so that payment can be made. The Jamaican dollar account has been established. Some people may want to do US dollar transactions, we have been told recently, and so we are getting a US dollar account also established. But the Jamaican dollar account is already established, and we expect to have the US dollar one in place. The website, everything in relation to the website, the testing, the security protocols, all of that around the website is in place, and so it will be made live for June 1. And that's been very important because we don't want to start with the paper. We want to actually start from the very beginning using the online process. And so they have said they will be ready for June 1 to receive the registration of the data controllers. In terms of small businesses and our MSMEs, that's a very important group. And we know in every country, the small business sector is what drives growth in our country. And we've reached out to the MSME Alliance, had discussions with them, and there were legitimate concerns about what this would mean for small businesses. But if we speak to the OIC, and when they do their presentations, one of the things that they always note is that you really have to take a risk-based approach to this. You know, if you are, and I gave the example of the shoemaker, who is very, very important to me because, you know, in Jamaica, the tip of your heels, always, because we use a lot of pebbled pavements and stuff, and it just doesn't work. But I use my shoemaker a lot. And he, you know, was concerned, actually asked me one day about data protection. And I said, okay, well, that's good. You know, he understands it, and if it applied to him, and what did it mean for him? And I think what we've been saying to the small businesses is, if you have data, if you have your customers' data written down in a book, you know, maybe what you want to be doing is securing that book that has a lot of information. We're not saying that you need to go and get a fancy set of equipment and software in order to be compliant. What we're saying is understand that when you have persons' personal data, you want to make sure that you are protecting it. That's the kind of environment that we are in. And so we would not say to them the same thing I would say to a telecoms provider. The telecoms provider has to have a data protection officer. The risk is much heavier there. And the OIC would not be going after a small player, because what we have said is that come June 1, the categories that I named out are the ones that are required to register. Anyone else who just loves this and loves where we're going as a country can register. But we will not, and we believe that we will have this in place for 1 year. It also gives us an opportunity, and you know that the law comes up for review, I believe it's next year, for us to even think, you know, do we agree with the terms in the Data Protection Act as they relate to micro and small and medium-sized enterprises? It's an opportunity for us, having put the legislation in place, to look at it, look at how it's being implemented. We will have data from the bigger businesses, and then we'll have an opportunity to, again, look at the extent to which we really believe that all of these dictates have to apply to every business, even a very small one. And so that will be, the onus will be on us to review the legislation. But in the interim, at least for the next year, those who are prioritized are the list that I gave. So my lovely shoemaker does not have to register. There's no requirement for him. There's no requirement for individuals who are processing under 10,000, have less than 10,000 customers, or data subjects that they're processing. No requirement. And if anyone has questions, as I said, you know, they gave 100 legal opinions. If you are concerned, if you fall kind of on the fringe of one of the areas, the OIC is very open to speaking with you, but I say definitively that our small businesses will not be required, as at June 1, to register. So small businesses, if you fall under one of the categories that I discussed earlier, if you're in health, if you're a government entity, you are required to register. If you're a telecoms provider, you are required. If you are a financial institution, you are required to register. But this requirement does not permeate to our small businesses. I had a question in relation to contact information, and the email is one that we put out quite a bit, which is info@oic.gov.jm. That's info, I-N-F-O, @oic.gov.jm. And their phone numbers, there are two phone numbers that they use, 920-4390. Sometimes, on occasion, that line goes down, and usually they make public announcements if there's another number that would be used. Let me see if there's any anything else? Cost implication, I said, yes, we understand the cost implications. There's actually a new industry that has arisen in terms of data protection. There are many individuals offering services, and I believe what has to happen, and sometimes businesses have felt that they need to spend a lot of money in order to be compliant. I would say the OIC is here. They are willing to speak to you, to talk to you about what is really required. What does compliance look like in your sector for your size business? They can say, for example, for a doctor's office, they've met with the medical association and said, this is what it looks like. We're not saying to you, you can't have your paper files like what you've had for a long time and you need to digitize them. What we're saying is if you have your paper files, you need to know how you are keeping those. Is it accessible to anyone who walks in? Can I walk in and just open a drawer and have access to someone's personal medical information? What it is saying is that you have to have systems in place to protect the data. It's not saying you have to go and buy a new multi-million-dollar system at all. And that is why these consultation sessions have been so important, and also the individual calls and the requests for legal information, legal opinion on implementation. And I think I answered the last one too, I think, Senator Allen, in relation to small business, because you were coming back to that and just noting that small businesses are not required unless you are a small business that is processing a lot of data. If you are doing over 10,000 persons, you may be working, for example, with a telecom or a bank, and you're processing data for them. Even if you're a small company, you're required to register. But on the whole, our small businesses will not be required to register at this point, Mr. President.
Of course.
Thank you. Thank you so much for the clarification, Minister. But further clarification, you mentioned small businesses under 10,000, but then on page 3, you gave some very specific categories. Am I to understand that if you are a small business processing less than 10,000 data subjects, 10,000 persons, but you fall into any of these categories, that you are required? Okay, so I think that wasn't so very clear. Thank you. On page 3, sir. Yes. Thank you so much.
Mr. President, through you, and that's a good question, and that's when you give categories of exemption, you have to really be able to explain it very well. If you're a small business and you process over 10,000 data subjects, I'm talking about over. If it's over, you are required. You are required to register. If you're a small business, very few customers, or in the hundreds, you are not required at this point. The only persons that are required are those who we've said, so those who are telecoms providers, those in healthcare, the government entities, and so that list that we've provided, and that will be publicized quite a lot over the coming weeks, they are the ones that are prioritized for registration. So our small businesses, if you are not engaged with over 10,000, you are not required to register. Under 10,000? Yes. Right, if you're under 10,000, but if you fall in any of the other categories. So if you are in health and you process, you're small and you are under 10,000, it doesn't matter. As long as you fall in that sector, no matter how small you are required to register.
Can I inquire, sorry, Senator Bunting, can I just inquire about your colleague sitting behind you there, pretending not to listen? Trade unions. Would a trade union fall into your category?
The good ones that have over 10,000 would definitely fall under that. And I think the good ones do.
And if I may use a mic that does not belong to me, does that also mean that their political parties are caught under the requirement? Those who have,
yes. according to the law that we all passed, every entity is required to be compliant with the Data Protection Act.
Once you have over 10,000.
Yeah, no, the law says
Yes.
everyone has to be compliant, every entity, every organization. What we've said is in the rollout and in the implementation, we prioritize certain groups. And those groups are those with data subjects over 10,000. If the political party falls in that category, then yes, they will have to be compliant.
Yes.
Yes.
Senator Gale, yes.
Yes, Leader Bunting.
Minister, the two questions. The first has just a follow-up on the costs. I was in conversation with the CEO of a large financial group, and not the modest size one I'm associated with, a large group, and at the time, and albeit this is new and it's just going in, but at the time, his group estimated it would cost $1 million a year to comply with the regulations, etc. Now, in the terms of his group, they will be able to afford it, but $1 million here, $1 million there, it all adds up, and it's ultimately going to be paid by the consumers. So I would really like as we go into the implementation of this, the Office of the Information Commissioner, to see how we can perhaps, whether by regulation or when we come to review the legislation, pay extra attention to these added costs, which will make us as a jurisdiction less competitive because of and will make the barriers to entry higher for new players to come into these sectors which you have identified.
Senator Bunting, explain to us, myself, who don't quite understand where this cost would come up. How do you practically, with the person that you're speaking about, how would they practically identify a cost like what you're talking about?
Well, the various measures and the various additional administrative staff, etc., that will have to be put in place. The policies, the reporting, oftentimes software, amendments to the existing software or new software to plug into the existing databases they have to ensure that it picks up and alerts potential breaches and so on. I can't speak to the budget of that particular entity, but it's a number of entities, regulated entities in the group. So if you have a bank, an insurance company, etc., unit trusts, they all have to put these, all the various boards, all the various staff, software, etc. So it's related to that. And as I said, the big entities, they can afford it. But ultimately, all this is passed through to the consumer. And they're under pressure right now from all the existing fees, etc. So we don't want to unnecessarily load up on those. But as I said, we will see as it comes, because perhaps in the implementation after the first year, they may find efficiencies that will come from repeating it over and over. But it's an area that we should pay attention to, because both from a competitiveness standpoint in terms of keeping out smaller players or new, a barrier to entry for new players, as well as making the local industry uncompetitive relative to our Caribbean and regional neighbors. So that's one concern. The second has to do with a very real instant case where an agency of government refused to disclose the names of two entities with which it had entered into contracts, costing taxpayers hundreds of millions of dollars. And they claimed that the Data Protection Act prevented that agency, the Tax Administration Jamaica, from doing so. This rightly, Mr. President, triggered outrage from transparency campaigners. And to the credit of the Office of the Information Commissioner, they contradicted the TAJ, saying the law supports transparency. However, and to my and I think all well-thinking Jamaicans, the TAJ came back the day after and said they defend their refusal of the access to information request from Gleaner on the same basis. And closed, the article closed, this is on the 20th of April, that the TAJ will engage the Office of the Information Commissioner to seek further guidance. I'm assuming now, weeks later, that an opinion has been provided to the TAJ to guide them, and I would ask the Minister to speak conclusively to the nation on the government. We don't want one agency saying one thing and another agency saying another thing. What is the position of the government on this issue?
Thank you, Senator Bunting. Senator Morris.
All right, thank you very much. And I'll start with the first part of your question, which was in relation to the costs. And yes, there are costs associated with protecting the data of our citizens. And for a lot of big businesses, they've had to put in place new systems in order to be compliant with data protection rules. But I think that if we talk to our citizens, they will tell you that this issue of data privacy is central to them. It is very important to them. And so I think this is a piece of legislation that was very much wanted by our citizens. And it does come with costs. And what we do in terms of the OIC, what they've been doing is any company can say, this is what I'm looking at. This is the set of actions that I want to take. Do I really need to go this far? They have seen instances where entities were buying software they really did not need. But we can always work with the OIC. Any company can work with the OIC in terms of saying, this is what I have. Do you believe that this is enough for me in terms of protecting data? And there will always be a response from the OIC. I don't really want to get into, the back and forth between different entities, but I think it is very clear. There are some things that are clear. The Data Protection Act is about protecting personal identifiable data. And it's very clear in the legislation what that is. So, like your name, your age, any health issues that you may have, very important pieces of your data, including your email address and your phone number, that you do not want out there. That in no way precludes an access to information request. If you have an access to information request, wherein giving it, you're giving personal identifiable information, then you cannot. Right? You cannot do that. But a name is, or a company, a business, that's just the business, right? And we need to ensure that we're going by the law. And the law does say that it is personal identifiable information and being able to protect that and not necessarily share that with third parties. The OIC remains in contact with the TAJ on that particular matter. But what I'm saying to you is, there are always going to be requests for information, and access to information is something that is prioritized by the administration. And we will continue to prioritize that because we believe people have a right to information in terms of what the government is doing. And we have to ensure that we preserve that and that this new law is not used on that basis. And we've made that very clear, that where there is a legitimate request for information, that must be furnished. And where there are doubts, there is the OIC that you can have discussions with to say, what exactly can I release? But we do not see the Data Protection Act, and it was never envisioned to be an act that would preclude the public from getting legitimate information that has been requested from the government, and we will not use it as such. And so as soon as I have the final verdict between their lawyers, and lawyers may have differences of opinion, but as I said, the basic principle is that we still believe that there is a right to information. There's a right to understanding what the government is doing. And so those requests that are coming in the information will be provided. And where there is doubt as to whether or not the data protection rules preclude you from doing that, the OIC will opine. And you saw in the newspaper the OIC as an independent body. You know, we are really in OPM just really giving the administrative support in order to have them established. But they are an independent body, and they gave their independent opinion on that matter, and they said that the data protection laws could not be used. Another entity did not agree, and that will always happen, and they are in dialogue with each other. And as soon as there is a final position, I am sure that TAJ will provide their position on this. But as I said, access to information is important and is prioritized, and we do not intend to use the Data Protection Act to stymie that.
Thank you, Senator.
I know the Access to Information Act is in the process of updating and amendment. And perhaps in that process, some of this could be made pellucid. So could you... So I was wondering if you could give us an idea of the timetable by which you think that would be process of the updating of the access to information will be complete.
All right. In terms of access to information and the completion of that, I mean, that's been something that we have spoken to on several occasions. I have not had the opportunity to speak to the Minister of Information and ask him for a timeline on that. But I can speak to him, and I will provide that information to you. And I know that, and I saw it with the very good news in terms of Jamaica's ranking in terms of press freedom this week, which was something that we should applaud, or late last week, which we should applaud. And yes, we really should. We definitely have to applaud Jamaica's movement in that ranking. And as a part of that, some of the statements that came from the Press Association actually spoke to the need to update the Access to Information Act, and that being something that would even further bolster our standing in terms of press freedom. And the government had previously indicated that this would be done, and I will seek to get an update from the Minister of Information to get back to you on that one.
Mr. President, can I make a brief intervention, if I may?
Oh, Don. Yes.
Yes, just me virtually. I hope I'm looking good virtually.
Yes, go ahead, please.
Two quick points. And as a Jamaican company that operates internationally, I can speak a little bit about Data Protection Act. And I think that's one of the points that we need to make, that any company that is doing business, even if you're a resident or located in Jamaica, and you're doing business internationally, this is not a nice to have. This is a must do. Senator Bunting, I've seen cases where there's a breach of the Data Protection Act, and as much as 3% of the global revenue is charged as a fine. So you would realize that it is extremely, extremely significant. So I just want to make the point. The first point is that this is not a local issue. This is an international issue. And I can tell you, the USA, especially the UK and Canada, they are very, very firm on it, and they are very detailed in terms of any breach of the Data Protection Act.
So, Senator Webby, sorry, you know that this is not a debate, so I take it that you have a question.
No, well, I just want to support my fellow Senator Dana Dixon in terms of what she's saying.
But you're going to have a question for her, no doubt. You can coach it in a question.
Yes, I'm going to do that. The second one, which is a question now, the million US that Senator Bunting spoke of, some of it, Senator Dixon, is what we refer to as one-off costs, upfront costs, and then you have recurring costs. Do you have any idea of what the one-off cost would be? Because the recurring cost is going to be much less.
Just before you answer that, Senator Allen has a follow-up clarification.
Thank you, Mr. President. And Minister, I understand that on the listing of industries that are required for the June 1 deadline includes tourism, but I had interpreted your previous clarification in terms of size, that would be the main qualifier, whether they would have to meet the June 1 deadline, and understanding that there are varying types of protection of data, not necessarily software type, but protection in general. I wonder if there is any consideration that can be given to those tourism entities that fall below the 10,000 data point, and to use the number as the qualifier and not solely the industry, because we understand and appreciate the vast coverage that tourism has in terms of the types of entities that fall into that category and how they might be impacted. And so I wonder whether any further consideration might be given to that June 1 deadline for those that fall into that category. Thank you, Mr. President.
Thank you, Mr. President. I had thought that my presentation would have been so boring that we wouldn't have had any conversations, but I'm very excited that we are also animated about data protection today. In terms of the one-off costs, and Senator Webby was very right that, and I had mentioned that competitiveness, in terms of our competitiveness, Senator Bunting had noted that these costs could affect that. But actually, for a lot of our big businesses that are planning to operate overseas or do operate overseas, being compliant with our local data protection rules actually gives them a competitive advantage. And so it's actually, you have two sides to it. Yes, it costs, but it also can enhance competitiveness. In terms of the one-off costs, it really depends on the business, the nature of the business, the kind of data that is kept. I can see a financial company, a financial group, having $1 million US in costs. That is possible, especially for those who want to have very sophisticated systems in place. They may even be using, AI tools and other tools as a part of their compliance, and also making sure that the company is compliant and that all the entities in their group are compliant and all their employees are compliant. And so it can cost a lot of money if you really want to be first rate, especially for those businesses that have clients overseas or are doing business overseas. So in terms of the one-off cost, it really does depend. In terms of Senator Allen's question, re-tourism, that is why we do all these consultations and we have all these conversations. And I've written down what you have said in relation to the tourism sector. A lot of our tourism operators, so for example, the tour companies and so on, they would have already been compliant to a large extent. You'd see them using the privacy statements, they're operating in foreign markets, so they're already compliant. And I think where you're going is, some of the smaller players in tourism, how do we have a carve out for them? And so I thank you for raising that, because as we are working through the details of the implementation, that's the kind of thing that we listen to and that we work to just work with whatever sector it is that may need extra time. And as I said, we're not trying to do this to catch anyone and to fine anyone at this point. We're trying to develop a culture of compliance with data protection and a healthy recognition that data protection is important for a business because their consumers are demanding it. And so when we're implementing, we're going to be implementing it with that in mind. And the OIC has also indicated that they're looking at other factors in terms of size. So we have the industry, you should be compliant, but within the next week, we will have further guidelines and we will take on board the suggestion that you have made.
Thank you very much. As you said, perhaps some of us would have thought that your statement would have gone without comment, but I certainly enjoyed the edification from your presentation and from the various questions. Announcements?
Laid on the table of the Senate is the following: the Trademarks Amendment Rules 2024 and resolution under the Trademarks Act. Under the National Identification and Registration Act, we have the National Identification and Registration Regulations of 2024 and resolution, National Identification and Registration Identity Services Regulations 2024 and resolution, National Identification and Registration Assignment of National Identification Numbers Regulations 2024 and resolution, National Identification and Registration Information Security Regulations 2024 and resolution, National Identification and Registration Appeal Tribunal Regulations 2024 and resolution. Under the Revenue Administration Act, we have the National Identification and Registration Electronic Forms Regulations 2024 and the Revenue Administration Assignment of Registration Numbers for Enrollment under the National Identification and Registration Act Regulations 2023. The Interception of Communications Amendment to First Schedule Order 2024 and resolution under the Interception and Communications Act, along with its related ministry paper number 13 of 2024. The National Minimum Wage Amendment Order 2024 and resolution under the Minimum Wage Act. The Minimum Wage Industrial Security Guards Amendment Order 2024 and resolution under the Minimum Wage Act. Annual report of the Devon House Development Limited for the financial year 2022-2023. Annual report of Jamaica Vacations Limited for the financial years 2017-2018 and 2018-2019. Annual report and audited financial statements of the Urban Development Corporation for the financial years 2016-2017 and 2017-2018. Annual report and audited financial statements of the Sugar Industrial Authority for the year ended 2018, along with its related ministry paper numbered 14 of 2024. Annual report and audited financial statements of the National Irrigation Commission Limited for the year ended 2021-2022, along with its related ministry paper numbered 15 of 2024. Jamaica's updated National Implementation Plan for the Management of Persistent Organic Pollutants in Jamaica 2023, along with its related ministry paper numbered 16 of 2024. Bank of Jamaica reports on performance and main activities of the Board of Directors for the financial year 2023. Transforming Education for National Development Year 1 Report, March 2024. Attorney General's Chamber's opinion dated July 14, 2023, concerning reports submitted under Section 36 of the Integrity Commission Act and Standing Orders Number 73D. Attorney General's Chamber's opinion dated November 6, 2023, concerning the tabling of Auditor General's submitted reports. Internal memoranda dated November 7 and 8 of 2023 from the Legislative Council entitled Opinion on the Reports on the Public Bodies submitted to the Parliament by the Auditor General and Opinion on tabling reports from the Integrity Commission and submissions of same to the Integrity Oversight Committee. Integrity Commission report of investigation into concerns that 1. Mr. George Callaghan, former CEO of the Sugar Industrial Authority, made false statements in the statutory declarations filed by him for the years 2018 to 2020. 2. Mr. Trevon Clark, an employee of Kingston and St. Andrew Municipal Corporation, failed to file his statutory declarations with the Integrity Commission for the years 2019, 2020, and 2021 in breaches of the Integrity Commission Act. 3. Mr. Charlton McFarlane, an employee of the Registrar General's Department, failed to file his statutory declarations with the Integrity Commission for the years 2019, 2020, 2021, and 2022 in breaches of the Integrity Commission Act. 4. Mr. Dwayne Vaz, a former Member of Parliament, failed to provide information requested by the Commission in respect of his statutory declaration for the year 2019. 5. Mr. Oral Reed, an employee of Kingston and St. Andrew Municipal Corporation, failed to file his statutory declarations with the Integrity Commission for the years 2019, 2020, and 2021 in breaches of the Integrity Commission Act, along with their respective indicative ruling. Annual report and audited financial statements of the Human Employment and Resource Training National Service Training Agency Trust for the financial year 2022-2023. The National Housing Trust, Housing Benefits, Special Selection, Silver Sun Housing Development Order 2024 under the National Housing Trust Act. Annual report and audited financial statements of the Broadcasting Commission for the financial year 2022-2023. Auditor General's Department audited financial statements for the Parochial Revenue Fund for the financial years 2020, 2021, 2021, 2022, and 2022, 2023. Auditor General's Department certified appropriation accounts, Head 1500, Office of the Prime Minister for the year 2015-2016. Under Head 19,000C, Minister of Economic Growth and Job Creation for the year 2020 to 2021. And Head 08,000, Independent Commission of Investigations for the year 2022-2023. And finally, the notification of the inflation target, April 29, 2024, remit for the Monetary Policy Committee, and recommendation of the inflation target, April 11, 2024, the proposed inflation target for the fiscal years 2024, 2025 to 2026 to 2027. Thank you, Mr. President.
I just want to make one comment. I know that it is one of the intentions of the clerk to seek to make amendments to the standing orders of both the lower house and the Senate, so that we can get away from this, because this is really not only a waste of money, but it is unmanageable paper. I also know that one of our territories in CARICOM have gone a long way towards doing just this, and I know that the clerk is in touch with the clerks there with a view to identifying the process of seeking to eliminate this. So certainly I'm sure that every member of the Senate would encourage you to move along that way, because in just sitting here trying to, I don't know if everybody has what I have up here, but in trying to wade through this, it's really unmanageable, and perhaps if it was in a different form, in a quiet moment, we would really spend some time on it. But this, I don't want to really, I could lie and say that I'm going to take this home and wade through it on the weekend, but I'm not going to. And I think that perhaps if it was in a different form. So we encourage you, Madam Clerk, to continue with that innovation. I know that it's going to require some changes in the standing orders, and it might require some changes in terms of staff personnel who would have the technical capacity to deal with this. So you certainly have, I can say, I think you have the support of the Senate in moving forward with this. Bills brought from the Honorable House of Representatives. Petitions, papers, reports from committees, notices of motions given orally.
Mr. President, in keeping with this suite of changes, as my colleague, Minister Morris Dixon, just did on the Data Protection Act, Mr. President, I now beg to give notice that in next sitting of the Senate, I will move the following motion: the Trademarks Act. The Trademarks Amendment Rules 2024 Resolution. Whereas Section 78 of the Trademarks Act, hereinafter referred to as the Act, provides that the Minister may from time to time make such rules subject to affirmative resolution. A, for regulating the practice under the Act, including the service of documents. B, for classifying goods for the purposes of registration of trademarks. C, for making or requiring duplicates of trademarks and other documents. D, for securing and regulating the publishing and selling or distributing in such manner as he may think fit of copies of trademarks and other documents, and E, for the regulation of trademarks. F, for prescribing fees payable under the Act. G, generally, for regulating the business of the office in relation to trademarks and all things by this Act placed under the direction or control of the registrar. And whereas, Mr. President, on the 25th of March 2024, the Minister made the Trademarks Amendment Rules 2024. Now therefore be it resolved by this Honorable House, Honorable Senate as follows. 1. This resolution may be cited as a Trademarks Amendment Rules 2024 resolution, and 2. The Trademarks Amendment Rules 2024 is affirmed. If it pleases you, Mr. President.
Thank you very much. Senator Dixon.
Thank you, Mr. President. Mr. President, I beg to give notice that at the next meeting of the Senate, I will move the following motion. And the first one, under the National Identification and Registration Act, the National Identification and Registration Regulations 2024 resolution. Whereas by virtue of Section 33(1) of the National Identification and Registration Act, hereinafter referred to as the Act, the authority may, with the approval of the Minister, make regulations generally for giving effect to the provisions of the Act. And whereas by virtue of Section 33(2) of the Act, such regulations may provide, among other things, for A, the forms to be used in connection with any application, notice, certificate, or other document required to be issued under the Act. B, the procedures and practices to be followed by the authority in the collection and verification of information required for the enrollment of individuals and the disposal of information collected in respect of an individual whose enrollment is refused. C, the procedure and processes for the manufacture, preparation, issue, surrender, cancellation, renewal, and replacement of national identification cards. D, the form and content of national identification cards. E, the procedure for the correction and registration of changes to the identity information of enrolled individuals. F, the fees that may be charged by the authority. G, the procedure for verification and authentication of the identity information of enrolled individuals. H, the procedure for archiving information in the custody of the authority. I, the procedure for the destruction of identity information in the custody or control of the authority, where retention of such information is no longer necessary for the purposes of the Act. J, the form of warrants to be issued under Section 29(1) of the Act. And K, any other matter required to be prescribed. And whereas by virtue of subsection 3 of Section 33 of the Act, regulations made under that section shall be subject to affirmative resolution. And whereas on the 8th day of May 2024, the authority, with the approval of the Minister, made the National Identification and Registration Regulations 2024. Now therefore be resolved by this Honorable House as follows. 1. This resolution may be cited as the National Identification and Registration Regulations 2024 resolution. 2. The National Identification and Registration Regulations 2024 are hereby affirmed. And I have 5 of these. Number 2, under the National Identification and Registration Act, the National Identification and Registration Assignment of National Identification Numbers Regulations 2024 resolution. Whereas by virtue of Section 33(1) of the National Identification and Registration Act, hereinafter referred to as the Act, the authority may, with the approval of the Minister, make regulations generally for giving effect to the provisions of the Act. And whereas by virtue of Section 33(2)(d) of the Act, such regulations may provide for the procedure for the generation and assignment of national identification numbers. And whereas by virtue of subsection 3 of Section 33 of the Act, regulations made under that section shall be subject to affirmative resolution. And whereas on the 8th day of May 2024, the authority, with the approval of the Minister, made the identification and registration assignment of national identification numbers regulations 2024. Now therefore be it resolved by this Honorable House as follows. 1. This resolution may be cited as a National Identification and Registration Assignment of National Identification Numbers Regulations 2024 resolution. 2. The National Identification and Registration Assignment of National Identification Numbers Regulations 2024 are hereby affirmed. 3rd, under the National Identification and Registration Act, the National Identification and Registration Information Security Regulations 2024 resolution. Whereas by virtue of Section 33(1) of the National Identification and Registration Act, hereinafter referred to as the Act, the authority may, with the approval of the Minister, make regulations generally for giving effect to the provisions of the Act. And whereas by virtue of Section 33(2) of the Act, such regulations may provide, among other things, for the procedures and processes for the storage, management, security, and confidentiality of information stored in the national databases, including technical standards with respect thereto for the preservation, custody, and safekeeping of information collected by the authority, and for any other matter required to be prescribed. And whereas, by virtue of subsection 3 of Section 33 of the Act, regulations made under that section shall be subject to affirmative resolution. And whereas, on the 8th day of May 2024, the authority, with the approval of the Minister, made the National Identification and Registration Information Security Regulations 2024. Now therefore be it resolved by this Honorable House as follows. 1. This resolution may be cited as the National Identification and Registration Information Security Regulations 2024 resolution. 2. The National Identification and Registration Information Security Regulations 2024 are hereby affirmed. 4th, under the National Identification and Registration Act, the National Identification and Registration Appeal Tribunal Regulations 2024 resolution. Whereas by virtue of Section 33(1) of the National Identification and Registration Act, hereinafter referred to as the Act, the authority may, with the approval of the Minister, make regulations generally for giving effect to the provisions of the Act. And whereas by virtue of subsection 3 of Section 33 of the Act, regulations made under that section shall be subject to affirmative resolution. And whereas on the 8th day of May 2024, the authority, with the approval of the Minister, made the National Identification Registration Appeal Tribunal Regulations 2024. Now therefore be it resolved by this Honorable House as follows. 1. This resolution may be cited as the National Identification and Registration Appeal Tribunal Regulations 2024 Resolution. 2. The National Identification and Registration Appeal Tribunal Regulations 2024 are hereby affirmed. And lastly, under the National Identification and Registration Act, the National Identification and Registration Identity Services Regulations 2024 Resolution. Whereas by virtue of Section 33(1) of the National Identification and Registration Act, hereinafter referred to as the Act, the authority may, with the approval of the Minister, make regulations generally for giving effect to the provisions of the Act. And whereas by virtue of Section 33(2)(1) of the Act, such regulations may provide for the procedure for verification and authentication of the identity information of enrolled individuals. And whereas by virtue of subsection 3 of Section 33 of the Act, regulations made under that section shall be subject to affirmative resolution. And whereas on the 8th day of May 2024, the authority, with the approval of the Minister, made the National Identification and Registration Identity Services Regulations 2024. Now therefore, be it resolved by this Honourable House as follows. 1. This resolution may be cited as the National Identification and Registration Identity Services Regulations 2024 Resolution. 2. The National Identification and Registration Identity Services Regulations 2024 are hereby affirmed. Should have read news, right? And thanks to the NITS team, Mr. President, who've worked really hard. And we have here Dr. Warren Vernon, who has been leading the project on this, and we've gotten very far, and I thank them.
Thank you very much, Minister. Questions and answers to questions?
Mr. President, I beg to give notice
Senator Bunting.
That at the expiration of 21 days, I will ask the Leader of Government Business in the Senate the following question.
Motions that may be made at the commencement of public business require notice. Motions relating to sittings of the Senate. Motions for leave to introduce bills. Presentation of bills without leave of the Senate first obtained. Public business.
Thank you, Mr. President. Mr. President, it is not intended to do any further business today, but I think we've had some robust discussion, even it seems to me some debate, but very important information shared with this chamber and shared with the public of Jamaica today on the data protection regime, which is going to be a critical part of us moving into a future of great possibilities, ensuring that there is greater personal protection and corporate protection of information as we proceed further down the road of digitalization. So I want to thank Minister Morris Dixon for her presentation and for colleagues for their interventions on the matter. And we look forward to debating the regulations and rules tabled today at another sitting. On that note, therefore, Mr. President, if I might ask that the Senate be adjourned for a date to be fixed.
Just before we conclude, I understand that there is an intervention by Senator Sapphire Longmore.
Thank you.
Senator Longmore.
Thank you. I rise on the motion for adjournment to recognize two matters of national importance that is being celebrated or was celebrated at the national level. The Child's Month, which is for the entire month of May, but also Teachers' Day, which was celebrated on the 8th of May this week. Mr. President, and the nation recognizes that it is a 70-year legacy. I did not realize this, that Child's Month has been celebrated in Jamaica. And it has become something that is on the calendar, I think, that we all recognize. And this year, I would want to also particularly pay thanks to Dr. Pauline Mullins for her tenure as chair for a number of years in that capacity. She actually passed on the baton to Nicole Patrick Shaw at the launch of this year's Child Month activities, and she was entitled Child Month Chair Emeritus because she has given such great dedicated service, and I really want to thank her for her tenure again. Mr. President, you know, the Ministry of Education and Youth this year thought it fit to have the theme, Stand Up, Speak Out, Protect the Rights of Our Children. And, you know, we have gotten up on so many occasions in this space to recognize the needs of our children and the need to protect our children. But I think we are so very much reminded now, the events of the past couple of weeks, months, of what we're seeing happening amongst our youth is of great concern. And no more time than now is when we really need to push for the protection of our children at all levels, at all spaces. Our children are so vulnerable. When we say they are the future, I think we are now really appreciating, because when we see the negatives that might be happening, we are getting a kind of a guttural fear as to what may come from what we're seeing now. And, you know, everybody knows my efforts in certain spaces, but particularly, and I have to bring it to the fore, the violence in our schools. Whatever each of us can do, however we can try to impart an anti-violence message, I implore us to do that. We have to have a collective effort at this recognition of protecting the rights of our children. You know, the persons, and I would want to pay some attention to the persons who do that protection. The parents, the families, the caregivers. The Ministry of Education is making great effort. The task is huge with what I think we're seeing. All agents, they're from their administration to their ancillary to the teachers. It is a great task, Mr. President. And increasingly, as we spoke, as Minister Dixon mentioned today and brought to the floor, the Data Protection Act, the online space, our children are increasingly needing our protection in the online space. And however I can use that advocacy to bring that awareness to parents and the caregivers, to spend 5 minutes, when you send the child to go have some screen time, spend 5 minutes to see what they are watching. Spend 5 minutes to listen. Sometimes the content of what is the audio that is going with some of these games, it is frightening. The virtual world, a lot of kids are now doing the VR. Limit the amount of time. Some of the VR games actually have a limit on them because it has been proven that it can affect the development of not just the vision, but the brain. So we must seek to protect in that space. As we enable Wi-Fi access, let us enable the awareness of the need to protect our children in these spaces. And Mr. President, as we seek to protect, let us protect our children's right to play. Let us protect our children's right to play. Their schedules can be so very heavy with the PEP preparation and the this preparation, the CSEC preparation, and just the technology and the protect their right to play. It is one of the most healthy things you can do for your child, and seek to play as a family so that they learn the values of family. Mr. President, our efforts, not just at recognizing the rights of the children, but also mental health issues, brought it necessary to actually have a specific day, the National Child and Adolescent Mental Health Awareness Day, which would be celebrated on May 30th. And the theme for that is Your Life Matters, creating safe spaces for our children. And we see efforts. We see efforts by the Ministry of Health and Wellness in terms of the wellness benches and so forth, to kind of give that concept of creating safe spaces to work through some of the issues that we go through sometimes. And our children must be encouraged to find these spaces. And of course, Mr. President, as I mentioned, Teachers' Day, Wednesday, May 8th, was celebrated under the theme of recognizing our children, our teachers. And I just have this one quote to leave where it says, teaching is the greatest act of optimism. And that, I think, speaks well, because every teacher who goes through, trust me, sometimes the homework, it reminds you that is a special skill is required for our teachers to impart knowledge on our children. And so I want to thank our teachers for the effort at all levels, from preschool, kindergarten, right up to our tertiary institutions. And lastly, Mr. President, though it was not mentioned in the introduction, I want to recognize someone and a group of persons who do both of these and do both of these tirelessly. Sunday is going to be Mother's Day. I want to wish us all who are mothers, and also those who mother without being a mother, happy Mother's Day. Thank you.
Thank you very much, Senator Sapphire Longmore. Senator Morris.
Thank you, Mr. President. I just want to join with Senator Longmore and other colleagues in extending or recognizing Child's Month.
Don't sit when you finish.
I'll remember. The theme, I believe it's very instructive, and it's a call to action for Jamaicans to really take a more concerted or make a more concerted effort to be a part of the solution to protecting our children. And I appreciate that. It's also a profound responsibility that we all have an important role to play in safeguarding the rights of our most vulnerable in the population, or children. Mr. President, we have had a rough couple of weeks when it comes to our children. And there are many parents, young people alike, who are concerned. I spoke to a young lady, and it was in the wake of one of the instances of violence in a particular school. And she felt scared. She felt genuinely traumatized at what was happening. And there are many, many of our children who unfortunately have that feeling that it could be me. And so as we celebrate Child's Month this year, I think that the call has to be even more loud and forceful, because we're now seeing the very real implications of not challenging some of these issues head on. And we can't keep waiting. We can't keep waiting. There are many solutions on the table. My colleague, Senator Crawford, he put out a raft of suggestions. 2 years ago, I myself put out a raft of suggestions. Civil society have been putting out rafts of suggestions. I know that Senator Longmore, for very long, has been putting out a raft of suggestions. And I believe that the time has really come for us to move with alacrity to change the social space that exists, and to put in the necessary support systems that will enable our children to actually thrive and feel safe in this country. When we look at what exists also, we have to take a step back and say whether or not we are failing our children. And I met a parent just this week, Senator Longmore, who spoke to me about her plight. She has a son who is on the spectrum. And she has been trying her very, very best. And it hurts me because I know that there's so many more parents like her who are doing the best they can, but they need additional support. I reached out to the ministry and I was happy to see that they obliged to have a meeting, not just with the parents, but also with child psychologists, who are too now underscoring the need for greater support for more psychologists to be dedicated to addressing the issues that our children have. And so that's a step, but it has to go a little bit fast and we have to be a little bit more forceful. When we look at the mental issues, a couple weeks ago, and I tell you, it's been a rough couple weeks, at my alma mater, it was strange, but we had a case of suicide. And we see that it's mushrooming in other schools across the island. And we have to be concerned about that, because there's so many children who, coming out of COVID, already they might have been disenfranchised, but going through such a pandemic that has really set many people back, there are many of our children who are struggling and don't have the tools to cope, nor do the parents have the tools to support them. And so there are two things that I would like to see. Going back to the issue of violence, Senator, you said that we need a national anti-violence message, but I think we need a national anti-violence campaign in general that stretches across various stakeholders, that stretches across various institutions, because we have to do something to cauterize the violence. We have to. So that's one. And the second thing is that I believe that while there are programs for child mental health, for youth mental health, I really would like to see us providing more structures. So social workers in communities, child psychologists, we have to see how we can have these support systems and networks readily available to our children, to their parents, to families, so that we can see the improvement and we don't have to wake up every day and hear these disturbing stories. And finally, I want to say to the public, the general public who might be listening, because a part of the theme speaks to protecting the rights of our children. And the minister, she reported that the CPFSA has said that there are 13,513 cases of abuse, child abuse. Even one is far too much. And so we have to start to become more aware and sensitize more Jamaicans about the real face of abuse. It's not just the physical abuse, while it's detrimental, but also we have to look at mental and emotional abuse that so many of our children are facing. When you say to a child, you're stupid, you're not going to turn out to nothing, you're blighting their future and you're setting them up to be, more disturbed as they go through life. And so we have to be aware of the phases of abuse. And I want to encourage parents. I know that it can, well, I don't know I don't know personally, but I gather that it must be a difficult job to parent. And it's even more compounded when you have children who do have special needs or who might be struggling emotionally or mentally. And so I want to encourage parents also to seek out support. There are support systems available, whether it's a counselor, a psychologist. Seek out support once you're able to. And I want to say to the public as well that the 211 hotline still exists. So if you know of instances of abuse, then it is your responsibility to stand up, to speak out, and to report, right? And finally, as I close, Mr. President, I also want to highlight teachers who are very important to the village that is essential to caring for our children also. This week, many of our teachers, they had a chance to take some downtime. And it's important because we see so many cases of teacher burnout. We see so many of our teachers, leaving the system. And so it's important that our teachers have that opportunity to be appreciated, have that opportunity to rest. And so I want to say to teachers everywhere, both my parents are teachers, and so I've seen firsthand how difficult of a job it can be to really hold the attention of our young people and to really mold and guide them. And so we know how much they do for our children. And today I really want to let teachers everywhere know that we appreciate the sacrifices, we appreciate the time, we appreciate the energy and effort that you put into our children, into our young people. And finally, this time, this is the real finally. She's rubbing off. Finally, though, Mr. President, we must also recognize, too, that our teachers, they are calling out for greater support because they're not leaving just because they don't love this country. They're not leaving just because they want to leave, but they're leaving because many of them, like I said, are having some real challenges in the classroom. And it comes back to the need for also addressing the problems that are happening with our children. Many of the teachers, they don't have the tools to deal with it. And so we have to get to that point where we place some special effort on equipping our teachers, providing greater support as well with our guidance counselors to ensure that we can address the needs of our children. So, Mr. President, I want to say Happy Child's Month. Finally, Happy Child's Month. Everybody, I want to encourage you also to participate in the activities that are happening. And Mother's Day. Yes, on Sunday we celebrate Mother's Day, and I want to wish all mothers a happy Mother's Day. Thank you for all you do to nurture our children. I hear you. So, Mr. President, with that I rest. Thank you. May it please you.
Thank you. Thank you very much, Leader.
Thank you, Mr. President. The motion on the table of the Senate is that the Senate be adjourned for a date to be fixed.
But it's so early. The question is that the Senate be adjourned for a date to be fixed. Those in favor? Against? The Senate now stands adjourned.